So the issue of a state outright banning concealed carry has once again been ruled on and struck down after the Supreme Court recently issued an 8-1 decision and remand in a different case. So let's break down what is happening in this critical concealed carry challenge. Now, really quick before we jump into this video, I want to wish everybody a happy new year. I hope 2025 is great for you and your family. And I also wanted to mention one of our sponsors, First Form. I know a lot of people maybe have a New Year's resolution to maybe get healthier and work out more. Check out First Form. I will leave links down to them below in the details section, pinned comment. They've helped me along with my health journey. I highly recommend them. They're Pro Freedom, Pro 2A. So again, check those links out. And if you order something $50 or more, you will get a free 4-pack of energy drinks using my link. As I mentioned in the intro, in this video, we're going to be discussing how the issue of concealed carry bans out of states like New York have once again been ruled on and actually struck down because the state is outright banning concealed carry, and this directly defies what the Supreme Court said in Bruin. You may recall also that recently the Supreme Court issued an 8-1 decision in Rahimi and then remanded another New York concealed carry ban case back down to the Second Circuit for a new decision in light of Rahimi. Now that case was Antonyuk, and that is very important also for what is happening in this other case that was just ruled on. This new case, Christian, which is a case that's been going on for a long time and has kind of trailed along with Antonyuk, this case has also been ruled on in light of what the Supreme Court said in Bruin, also in light of what the Second Circuit said in Antonyuk. In this case, the District Court has issued a motion for summary judgment in favor of FPC and the plaintiffs, striking down the catch-all concealed carry ban that prevents carry at private locations without the consent of those property owners. This ruling strikes another major blow to the state of New York's law, which is directly defying that Bruin decision and is trying to outright ban concealed carry within the state. This ruling by the lower court has been appealed to the Second Circuit by the Attorney General in New York, Letitia James, and also there is that looming Supreme Court cert in the Antonyuk case. So there's a lot going on with this issue that we need to talk about. Now, this issue of concealed carry in New York has been a long battle and should have really ended after Bruin. In Bruin, the Supreme Court struck down New York's original May issue CCW licensing permit and that whole scheme, and they found that it was inconsistent with this nation's history and tradition. However, despite that, like I mentioned, the state of New York passed the CCIA just 8 days after Bruin, and they did that in direct defiance to what the Supreme Court ruled. This law was challenged in multiple cases, and preliminary injunctions were granted in multiple cases against the various aspects of the CCIA. However, the state of New York appealed those decisions up to the Second Circuit, who then granted blanket stays in multiple cases. In response, you had GOA in the Antonyuk case who sought emergency review from the Supreme Court. The Supreme Court, on review of that emergency application, denied relief, but they did issue an order to the lower court, to the Second Circuit, saying that they couldn't drag their feet, they needed to expedite these cases and at least give a rationale of why they're granting these blanket stays. The Second Circuit decided to review these cases, and recently the Second Circuit ruled in 5 of the CCIA cases, including the Antonyuk and the Christian case. And in that decision, the Second Circuit found that they did not believe that these issues, the CCIA here, was an exceptional case. They found that Bruin was an exceptional case, but they tried to distinguish all these other lawsuits from Bruin. Therefore, the Second Circuit vacated a lot of the district court's injunctions in some of these cases, finding that virtually all of the CCIA could be facially constitutional under the Second Amendment. Now, in response to that, GOA in the Antonyuk case then filed a second petition for emergency Supreme Court intervention. Again, that was an interlocutory case, interlocutory posture dealing with the denials and reversals of preliminary injunctions. But then a good sign came out of the Antonyuk case. The Supreme Court decided to grant, vacate, and remand the Antonyuk case back down to the Second Circuit in light of their 8-1 decision in Rahimi. Originally, the Second Circuit was intending to have all of the consolidated CCI cases reopened and reheard, but then they decided to move forward just with the Antonyuk case because that was the only case that was GVR'd in light of Rahimi. And on re-review, the Second Circuit ruled the same way. Rahimi didn't really change anything, and we did not anticipate that Rahimi would change the outcome of the Second Circuit. They were going to rule the way that they wanted, but one of the good things that they did find is that the catch-all provision, the provision there where private property owners would have to affirmatively give you permission to concealed carry at those locations, the Second Circuit found issue with that aspect of this law. The Second Circuit in the Antonyuk case also went out of their way to point out how they disagreed with the Ninth Circuit's recent decision in the Wolford, Hawaii concealed carry case. You may remember that in Wolford, the Ninth Circuit upheld the state of Hawaii's concealed carry ban, which had a similar aspect where you would have to get the confirmation from the private property owner that you can carry at that location. The Ninth Circuit upheld that Hawaii statute because they believe there was various ways that the property owner could give you consent to concealed carry. It wasn't just a sign. They could affirmatively, give you oral consent, say, yes, you can concealed carry here. And there was other ways they can do that. But here the Second Circuit said, no, it doesn't really matter. This does not have history or tradition to back it, and therefore we're going to reject this catch-all provision. So that was good because not only were they rejecting the catch-all concealed carry ban, but also it created kind of a circuit split between the Ninth Circuit and the Second Circuit on this critical issue. Now that was also good because the Christian case, like I mentioned, was trailing behind this. It was still at the lower court level because the only case that got re-reviewed at the Second Circuit was the Antioch case. But in this Christian case, the lower court judge was moving this towards a final resolution, and there were cross motions for summary judgment. What that means is that each of the sides wanted the district court to rule on one or more of the aspects of this case on the final merits, and they wanted that at an early stage of this case. And on review, the district court judge granted FBC's motion for summary judgment, striking down the state's broad concealed carry ban provisions. In the decision, Judge Sinatra stated that a newly enacted New York law makes it a felony for a concealed carry license holder to possess a firearm on all private property unless the relevant property holders actually permit such possession with a sign or by express consent. At least as to private property open to public, New York's restriction is unconstitutional, a result dictated by the teachings of the Supreme Court's recent cases addressing individual Americans' rights to keep and bear arms. Regulation in this area is permissible only if the government demonstrates that the new enactment is consistent with the nation's historical tradition of sufficiently analogous regulations. New York fails that test here. Indeed, property owners have the right to exclude, but the state may not unilaterally exercise that right and thereby interfere with the long-standing established Second Amendment rights of law-abiding citizens who seek to carry for self-defense on private property open to the public. So there you have the lower court outright rejecting this catch-all concealed carry ban. The court relied on the Second Circuit's prior decision in Antioch and the Supreme Court's rationale in Bruin. So the state of New York's justifications for the concealed carry bans have been outright rejected by the Second Circuit and now also by this district court judge, Judge Sinatra. Now, very important for this case in Christian, the Attorney General Letitia James has appealed this decision up to the Second Circuit, and she's seeking a reversal of what the district court ruled. However, as we discussed in prior videos and earlier in this video, there is a big wrinkle where because the Second Circuit recently ruled in the Antioch case on a very similar issue, now, once again, there's the option to go to the Supreme Court after the Supreme Court GVR'd this case in light of Rahimi, go back to the Supreme Court for a re-review of what the Second Circuit said. In fact, the Second Circuit and the lower court in the Antioch case have kind of stayed some of the proceedings. They said, because the plaintiffs have until January 22nd to seek Supreme Court review, they're going to halt a lot of the review of that case until, that develops. And because of that, in the looming cert petition that's potentially going to happen in Antioch, the lower court also in this Christian case and the Second Circuit are, saying that they want additional briefs on whether or not they should stay any proceedings in this case because of that looming Antioch review. Now, despite what happens at the Supreme Court level, if they grant that petition in Antioch or not, on appeal in this Christian case, the Second Circuit is likely going to rule the same way. This is an appeal specifically on those catch-all provisions, which have already been rejected by the Second Circuit. So I don't anticipate all of a sudden they're going to do a 180 and uphold the catch-all provisions here in this Christian's case. Essentially, they're probably just going to say, we already handled this in Antioch. Yes, the lower court got this right. It should be struck down. But overall, there's great news because now multiple courts have outright rejected the state of New York's catch-all concealed carry ban. There's also good challenges going on in other circuit courts. And now the Second Circuit will probably reject this again in the Christensen appeal. And now we're going to wait also to see what the Supreme Court wants to do in the Antioch case if the petitioners in Antioch decide that they want review from the Supreme Court. So as more things develop, as things change, I will let you guys know. But as always, thank you guys for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.